All right. Well, hi everyone. My name is Rob Solt. I'm one of the litigation and employment law associates here at Bugby and Conkle, and I'm joined by Carl Habekost, who is the head of our employment division. And we've got a pretty interesting presentation, I think, for everyone today on some of the various ways that COVID-19 and the coronavirus pandemic have been affecting employment issues, and some strategies and really how to protect your interest as an employer during this time. So we're going to cover a couple different things. We're going to talk about some remote work policies, which seems to be one of the growing trends. Prior to this year, I think the only time that we would just be discussing a remote was in reference to the TV control. Obviously, that's changed. So we're going to talk about some remote policies, some potential issues in the context of workers' compensation claims that can arise from these remote work policies. We'll talk about some return to work policies. One of the things that we've also seen that have started to trickle in are some COVID-19 workers' compensation claims. So we're going to discuss a couple of the claims that we've dealt with so far and how to defend against those claims. And last, we're going to talk about some of the federal legislation that's been passed specifically in regards to COVID-19, mainly the FFCRA, which is a fun acronym that we'll dive into a little bit as well. To start with, what we're going to do is we're going to start by talking about some remote work policies. So Carl, if I can get there we go. Take it away, Carl.
This is a very strange time, and dealing with COVID-19 and the ever-changing regulations is like trying to hit a moving target. So what we are going to cover really are just some basics. Anytime you are bringing your people into the office and exposing them to a hazard, you need to do a risk assessment. Now, there is going to be, at some point, there is going to be a regulation or a policy, you want to call it a COVID-19 policy, that's going to come from OSHA. There are some states that already have a COVID-19 plan. So some of the things we're going to talk about is really being proactive on the part. You're going to be required to develop a COVID-19 plan. You will need to develop a basic infection prevention plan, and you're going to have to train your people. And always, as is always the case, anything you do needs to be documented. I don't know how many out there has had to deal with a governmental agency, either OSHA or the EEOC or the House Civil Rights or anything to do with the Department of Labor. And anytime you're dealing with a government agency, if it ain't documented, as far as they are concerned, it didn't happen. So we're going to talk about documentation and retaining the records that you develop. As always, before we move on to the next slide, we like to say that the primary point of any COVID-19 policy is to protect the most important asset of your organization, and that is your employees. If you focus on doing that, then 95% of the time you will be compliant with the various rules and regulations that seem to be changing. Even now we're in November, they seem to be changing regularly. So we're going to cover a little bit of that. Risk hazard assessment. There are different ways to approach this. One of the primary requirements of OSHA and any health organization By the way, don't forget the Department of Health has jurisdiction on COVID-19 issues as well. One of the first things these organizations or these administrative agencies look at is what kind of hazard assessment did the company do? What kind of risk assessment did the company do? You will need to do various things. And I'm talking even preparing the building before the workforce gets back in there. If you haven't experienced this already, you will. People are very anxiety ridden about working and being out, moving around during this pandemic. So you're going to have to deal with angst and anxiety of your employees. The best way to deal with that is to communicate with them. Let them know what the organization is doing to protect them. We will recommend, as you'll see as we move through here, controlling access to your building, to your work environment. You will need to create a social distancing plan, and something as you might think is very simple, but you'll need to reduce touch points. For example, find a way to keep individuals from setting their hands one after another on lunchroom refrigerators, coffee machines, bathroom doors even. So there are ways to avoid having hands touching these common touch points. And you should do so because one of the ways COVID-19 is transmitted is by touch. That is not the primary way. The primary way is airborne particles or droplets, they're called. So now for those of you who are not safety specialists, you're basically HR people, this is an important slide. This talks about how to do a hazard assessment and how to protect employees in no matter what environment. But this is a recommended procedure specific to the COVID-19 pandemic. The first way that you can address, and the best way you can address protecting your employees, is simply to eliminate the hazard. That's kind of difficult with COVID-19, and I'm being a little bit sarcastic. There's no way to eliminate the COVID-19 virus unless we're going to have a vaccine. So elimination or substitution, which is the best way to avoid a hazard, is to engineer it out. And what that really means is change the physical workplace. We're going to talk about how to do that. That's where social distancing comes in. Plexiglass is put up, and then you'll have administrative workflow. So you're going to change the traffic pattern in the office. That's a good way to do it. And the final thing is personal protective equipment, and by that we mean facial covering, facial masks, face shields. The problem with the last two, administrative and work practice controls and personal protective equipment, is that you're requiring employees to do something. So human beings make mistakes. The best way to protect your people is to engineer the problem out. So let's move on to the next slide. For documentation, and this is just sort of like I said, this is like a COVID-19 return to work 101 level, a freshman course. But you should come up with something like this and then be able to document when a government agency or a health department comes and asks what you've done to protect your people. And by the way, it does help the thought process to protect your employees. Go through and evaluate, document the date, the actual job. You should do this for each job, and I'm not talking every single job, but job classifications. So if you are in a production environment and you have the production area, then you can just say, maybe area 13, or that's an unlucky number. We don't want to use that as an example. Maybe it would simply be, machine operators, or in the office environment, it would be basically the open office versus closed office environment. And then whoever's evaluating the jobs, the duties that that particular job classification performs, and then determine the exposure level. Now, for most, we would refer you to the OSHA pyramid of risk, but for most non-healthcare organization employment situations, you're going to be at the medium to low risk of exposure, especially if the company reduces exposure to the public. If you're in a retail situation where you have people coming in, such as in restaurants or stores, that is medium to high risk. So that's the kind of thought process that you go through. And once you determine the exposure level, then you go through the pyramid we just went through. Can you engineer out exposure? You have to change the administrative process and procedures. And if not, then you're going to move to PPE, which are facial coverings and sometimes gloves, some kind of protection for the hands. Okay, next slide. Thank you. Now, what is going to be required? And like I said, it's already required in 2 states that I'm aware of. No, 3 states, California, Michigan, and Virginia. They have COVID-19 emergency plans. Every one of those states has the requirement that a company have a written COVID-19 plan. We can expect within the next few months that there will be a national requirement for some kind of written COVID-19 pandemic plan. Every one of the states has common characteristics, these state emergency COVID-19 plans. First, you have to designate a COVID-19 person. And if you're a large organization, that might be, more than one. But there has to be a touch point for your employees to know that this person or this department is in charge of the COVID-19 plan. We're also finding with our clients that sick leave modification policies are necessary. So the COVID-19 plan needs to address the sick policy, the written remote work policy, which we're going to get into in a minute. You have to address that in the COVID-19 plan. Basic things such as daily screening. Do your employees self-assess? For example, do they take their temperature on their own? Do they complete documentation indicating whether or not they have symptoms of COVID-19, coughing, aches and pains, that sort of thing? And then you'll need to review the prevention measures that the company has taken, and that can be as basic as hand washing procedures, facial coverings, social distancing, remodification of the actual workplace. So we've had clients that actually changed their production lines so that the workers are more than 6 feet apart from each other. That can be difficult, but something along those lines. So these are not everything that's covered in a COVID-19 plan, but these are the main points that you will need to cover in your written plan, and it needs to be in writing. Once again, I said it before and I'll say it again, part of this process is for you in management to go through the steps that you need to go through mentally before you implement your plans. And it's also then a resource for your employees. Next slide, please. Prevention and exposure control plan. Seems kind of basic, doesn't it? But it is, believe it or not, it is, it's so simple that you just believe that people know how to do this. But there's actually a science to hand washing. The scientific data reveals that in order to kill the germs that are on hands, there has to be a certain configuration in the soap that you're using, and it has to be in contact with the skin for 30 seconds. So you need to basically explain to people proper hand washing techniques. There are also signs we recommend, and they're easily available, readily available on the internet, that explain how to wash your hands. So we have clients that we've recommended they put these instructions on hand washing in the restrooms. And I know it sounds kind of maybe almost funny, but it's very important. The recommendations from the medical experts indicate facial coverings and hand washing, along with social distancing, are the key to preventing the spread of COVID-19. Facial coverings, you need to touch base on that in your control plan. Talk about what they are, how often they need to be washed, or there's a company providing facial coverings. Basically, I know the Ohio Bureau of Workers' Compensation provides masks for people, and they're just wear them once and you throw them away. Once again, I talked about social distancing. That's important. Avoid in-person meetings. Have all your meetings done electronically or virtually, I guess is the right word. If somebody's sick, they need to stay home. And that will then get to when we cover remote work policies. But staying home when you're sick is more important now than ever. And obviously, you don't want to share keyboards, cell phones, desk phones, foods, any high-touch items. People need to avoid sharing those. We have to change the way we behave. It's hard to change behavior patterns that we've developed over a lifetime. Hopefully, this strange virus will go away. What I've been told by a friend of mine who's a doctor and a specialist in public health is that this is the same coronavirus that has been around for 20 years. It is just mutated. And that is what viruses do. They mutate and change. So we may have another version of the coronavirus in a few years, probably not as severe as COVID-19. COVID-19 is a very severe version or very severe mutation of the basic coronavirus. And by the way, it does help to give basic explanation to your employees, basic training on what the coronavirus is. What is COVID-19? Doesn't have to be complicated. It can be 2 or 3 sentences, but it does help to tell people a little bit about the coronavirus. Next slide, please. All right, I emphasized both on this. Managers need to be trained as well as employees, and there needs to be documentation that both management and employees were trained. That is where the COVID-19 coordinator comes into play. You should have one person or a small group of people who are educated on the coronavirus, educated on prevention plans, the policies, and they will then begin the training. So both managers and employees need to be trained on this. There has to be an open line of communication. Employees need to feel comfortable reporting symptoms, and how do they report them? And also, if I don't have it in the slides, you should definitely always be sensitive to the fact that you cannot retaliate against any employee for taking advantage of some of the laws that we'll cover real quick that have been enacted specific to COVID-19. The employees cannot be discriminated against or retaliated against in any way. We do know the Ohio Civil Rights and the EEOC is emphasizing non-retaliation and non-discrimination in this area. So be very careful. So save the training records. For God's sakes, save the training records. Any agency that comes in and does an investigation responding to a complaint is going to want to know, did you train your people? So the first thing they're going to ask for are training records. You can say, you have the opportunity right there to set the impression with this person from a bureaucracy that you're on top of it, you know what you're doing, here are the training records. So you can either save them electronically and can retrieve them easily that way, or save them paper. But however you do it, having them in one place, being able to pull them up when requested, is a good way to start any investigation with the investigator. Okay, next slide. I've already begun to talk about this. Documentation. Document all training records, which I just covered. The next point, employee and visitor screening. Make sure that whatever documentation you have says a log, and it's not a medical record. If you're calling this a medical record, that brings into play all kinds of other laws and retention periods, saying you don't want to have to deal with that. So you're just keeping track of employees and visitors screening data in a log. If somebody tests positive, and depending on the jurisdiction, if they were near someone or associated with someone who was positive, you may have an obligation to report to the health department. So you want to keep records of that. As I indicated, employees can self-assess, and there are forms that you can put together for that. You can keep those forms either weekly. They need to do it daily, but maybe they'll turn the forms into you weekly. There is no, well, at least, I'm always big enough of a person to say I might be wrong. I would recommend that you keep these records for a year. That's what I've heard. That's what I've seen. And if somebody has a different idea on that, you've got some data on that, please let us know, and we will ship that out to everybody who's on the webinar. But other than that, we recommend 1 year, retain the records. Next slide, please.
I think, Carl, actually, I'm going to
yes.
on for a little bit here. So obviously there are some circumstances when employees may be required to or encouraged to work remotely. And so we thought that it'd be very important kind of to talk about some potential issues that arise with an employee that's working at a site that is not the standard place of employment. Particularly looking at in the lens of, say, a workers' compensation claim. Most of you may know that the standard for a workers' compensation claim is an injury that's arising out of and in the course of employment. Okay, well, let's say someone's working from home. Can they have a workers' compensation claim if they're injured in their own place of their own residence? The answer is potentially. And strangely enough, there are actually a handful of cases that have occurred prior to COVID addressing remote work. The first one is actually dogs. This sounds really strange, but there have been cases in the state of Oregon and the state of Florida specifically involving an employee that was working remotely and tripped over their dog and got injured. The Florida case was somewhat interesting in the fact that the trial court actually allowed the claim to go forward. They said that was a work injury. Ultimately, though, on appeal, the appellate court in Florida said, no, not quite. The circumstances involving the Florida case, the employee had gotten up from her table to get a cup of coffee and tripped over the dog. So they said getting a cup of coffee was not arising in and out of the course of employment, so that did not qualify as a compensable injury. There was a case out in the state of Oregon, a little bit different. The employee was working, I believe he was either in upholstery or working with some type of fabric, and had gone to get a package of fabric and was carrying the package in and tripped over his dog and was injured. The court actually upheld that one and said, nope, that was in the course of employment. So putting these potential issues, these are more to get everyone thinking about what areas could have some issues in the workers' compensation section. It's not been very well litigated in the state of Ohio. So there's not a whole lot to go on. And whenever you hear an attorney say that something is interesting, that usually is not a good sign, because that means we're thinking about it. We don't have a clear-cut answer, but all these are pretty interesting. Some other potential issues that we see with remote work are injuries that could come from working on a computer. So typically, if someone is working remotely, they're obviously, we're not going to see a lot of manufacturing jobs that are working remotely, just by the nature of their work. So with computer work, could we see more claims for carpal tunnel syndrome? Potentially. What about eye issues or back issues due to posture? I mean, if there's a teacher that is used to teaching in a classroom and suddenly she's now presenting via Zoom for 50 hours a day, that could be an issue and could create some additional conditions. There's a question as to whether or not someone, if they have added stress, could that, and they have a heart attack while working, could that be compensable injury? Certainly is a possibility. And even in the brainstorming for this, looking at some freak accidents that the employer may not have complete control of. What if someone's working in their front room and someone drives their car through their house? They were working, is that a compensable injury? What if their house is struck by lightning or catches fire? I mean, these are the issues that when we have remote work, they create a possibility, and we'll get into it shortly, but it's why it's very important to have a good remote work policy to protect the employers as much as possible. The last main issue in those issues is, all right, well, someone says that they were injured while working remotely. How does the employer investigate that? You can't necessarily investigate the site. Potentially, you're not going to have witness statements like you would in a typical workplace environment. It creates a lot of issues. So, again, the whole point of this slide is primarily to get everyone to think about, working from home is not the same as just, it's not as simple as just picking up a computer and working in a different location. There are a lot of considerations that, as an employer, you need to think about. So with that being said, let's talk about the steps to a good work remote policy.
Yes. Well, we can cover this slide pretty quick. As everybody knows, even if you weren't aware of before, you're aware of now, that health agencies and the governments recommend remote work if feasible. And that basically means if it's possible. Part of the problems we run in, not only with the work environment, which Rob covered, the actual physical work environment, but sort of the casualness that people adopt, this casual attitude when they're at home. We need to specify in the written remote work policy that employees still have to follow the standard, I'll call them handbook policies. That includes keeping information confidential, files of clients and data confidential, data and information of the employer confidential. The employees also need to be made aware specifically in the policy, what are their hours of work. That's extremely important if these are non-exempt employees. Those are the hourly employees, right? So we need to make sure that those policies are clear about hours of work. You don't want to get into a problem where somebody's working more hours than they should, and then you've got overtime issues. Conversely, you want to make sure that they understand they still have to be productive. The only thing that has changed is they're working from home as opposed to working in the office. That's it. So all the expectations are the same. Productivity, hours of work, etc. Next slide. We can make these slides available to you. This is just something that I put together quickly. Once again, it's not the begin all and end all, and it really doesn't even have all of the issues because we wouldn't have had room. But something like this: name, job title, where are they going to work? They're going to work at their house. Okay. Have a conversation with them about where at in the house. Where they're going to work is going to have some privacy there. And I say this having raised 4 children in my life, and we've got 2 dogs and 2 cats running around. So I understand the sometimes turmoil and challenges of working remotely from home. But nevertheless, you still need to emphasize to the remote workers that, hey, this is work, and we still have a reputation and an image to our clients. And by the way, you have an image that you're going to portray to me and other supervisors. So, be professional as much as possible. This is an issue. The first point: employee will be accessible and productive during scheduled work hours. Everybody has to be flexible. Just because someone you can't physically see them sitting at their desk, and if they're at home, merely because they don't respond for 5 minutes doesn't mean they're not working. Maybe, they actually went to the bathroom or something. So I've had clients who have a difficult time with that, and they want to institute some form of discipline when I don't even know how to, I don't even know how to begin in that situation unless you have a camera. You're actually watching what they're doing, and then you get into privacy issues. So you don't want to go down that road either. They need to understand the handbook policies and procedures are still effective. They have to comply with them. As Rob talked about, they have to establish a safe and appropriate work environment. What's not in this policy, but you should have on your policy, is what company machinery and property do they have to work remotely, and they're responsible for the care of that machinery and for the return of that. Most of it's computer oriented: a computer, a printer. Just identify it. Things can come up missing if it's not in the policy, and they got squatters' rights, so to speak. So they've got the computer at home, and they've been using it for a year or so, and the HR manager forgets about it because HR people deal with everything under the sun, and 2 or 3 years down the road, somebody wants to know where that computer is. That the bean counters, the accountants are going to know where that $1,500 for a computer and a printer, where is that? So you have to be able to pinpoint responsibility of the employee returning that. And that's really it. They need to sign it, and you need to keep it in your files. Next. And I think, Mr. Solt, this might be where you take over again.
Yep, back to me. So what happens in the horrible, unfortunate circumstance that you have an employee that contracts COVID? Okay. Um, uh, Part of the issue is early on, in the office we discussed, is that a potential for a workers' compensation claim? And in short, it appears that it can be filed. So the first issue is that something? Why would you want to, as a company, defend against these type of claims? The first thing is it's an unknown territory. And we've talked about, or everyone I'm sure has heard, that the coronavirus is this novel virus. Well, it's creating a lot of novel circumstances that we still fully don't understand. First and foremost, we don't understand the full lasting effects of the virus itself. There has been a lot of talk of myocarditis, other lung issues. I saw an article just this week that is linking some psychological issues to COVID infections. And so the way that the workers' compensation system in Ohio is set up, if you have that, more or less, that foot in the door with an allowed claim, this could be something that could grow exponentially to the conditions allowed, and it greatly affect premiums down the road. One of the things that we actually look at this as almost similar to is almost an asbestos claim, that there was some type of injurious exposure at some point, and it creates issues for companies many, many, many years down the road. So first off, the question is whether or not, in Ohio, a compensable act or compensable claim can be either an injury or an occupational disease. And would COVID-19 fall under which one of these would it fall under? The answer is it kind of depends. It depends on the specific circumstances of the contraction. For both of them, there needs to be that initial injurious exposure, which we'll get into a little bit. But the best way we thought to kind of explain this, or go through a case study of two claims that I've dealt with both of these now from their inception and all the way through the administrative agency. So these two claims were for COVID-19. It was the same employer. It was a retirement home and employees that worked in the COVID wing of the retirement home. So the first claim, we'll call that Claim A. In May, there was a positive test that it indicated positive for coronavirus. It didn't actually specify whether or not the test was an antibody test or a current infection test. That employee was quarantined for 2 weeks. Effectively, the letter says the evidence they presented, the medical evidence, stated that the injured worker was exposed to someone who tested positive, and that they later contracted COVID. So during the hearing, the claimant did appear for this hearing. She stated that she only went to the only place she went during the time that she was exposed was work. That she wore an N95 mask at all time at home, even though she had 10 other people that lived in the household with her. She testified, although it was difficult to prove, that no other household members were infected. And she testified that there are a whole bunch of people at this facility that were infected. The district hearing officer allowed the claim for COVID-19, and he awarded temporary total disability for the time that she was in quarantine. That case was appealed, and I think about 3 weeks ago or so, we had the staff hearing officer, and she upheld the district hearing officer's order. We presented again evidence that there was proof that she was exposed and there was proof that she contracted COVID, but there was no proof that the exposure is what led to her contracting COVID. There was a second claim from that exact same facility, the same employer. The first report of injury didn't actually list COVID-19, which is the disease resulting from an exposure to the coronavirus, but simply listed coronavirus as the description of the accident. She never provided test results, but there was a letter that stated that she had tested positive. She didn't appear for the claim hearing, and thankfully the district hearing officer dismissed that case. I'll tell you that claim A has finished administratively, and we're in the period to appeal to court has not yet run for that matter.
Hey, Rob.
Yeah.
Rob.
Yep.
Some just popped into my head, and for our attendees on the webinar, this is totally unrehearsed, so he has no idea what I'm going to ask. But it just popped into my head that if the hearing officer awarded temporary total compensation for the 2 weeks of quarantine, I wonder if that individual also was paid salary or paid their income under the Emergency Paid Sick Leave Act, which is part of that Family First Coronavirus Response Act.
That's a great question. The interesting part about the district hearing officer awarding temporary total disability is that the claimant didn't actually request it. It was just tacked on there, and that was raised at the higher administrative level. And that argument also did fall flat when I raised it that there was no basis for the temporary total disability. So,
so for audience members, this injured, well, so I'm going to call him an injured worker. I think that's questionable, but this person who was granted a COVID-19 workers' compensation claim may have double dipped. We'll talk about the Family First Coronavirus Act in a little bit, but I'm sorry, Rob, go ahead.
That's fun. It's also somewhat noteworthy in that claim A, she was asymptomatic, so she had no symptoms, but as she was a healthcare worker, as viewed by the state, she was able to get tested when she knew that she had exposure to someone with coronavirus. So we're dealing with someone that it was an interesting set of circumstances with her specifically.
There you go, using that legal word, interesting.
Interesting. I know that's not what people want to hear. So going forward though, how on earth would an employer defend against these COVID-19 claims? Well, the first thing is similar to, like I said earlier, like an asbestos claim. They need to show that they were injuriously exposed to COVID-19. Now, looking at the case study that we just did, that's a little bit of a different situation where you have an actual healthcare worker that has a direct exposure. In a normal circumstance, so if you have a manufacturing facility, it will be very difficult for a claimant to say that they were exposed by one specific person at that facility. So obviously one of the areas that we would argue is that they could have been exposed in some other area, whether that's in public, whether any other household members. And going back to what Carl presented earlier in the presentation is how has the employer made the facility as safe as possible to protect against COVID-19? Do they provide PPE to the employer? Have they taken the steps to limit social distancing? Have they trained their employees, and have they documented that training? I mean, these are all areas that may seem trivial to begin with, but they can have lasting consequences for the company down the road. Last, one of the things, or not last, but we'll also want to look at the medical documentation that the claimant would have for a COVID-19 case. I think most people are aware that the tests are varying in accuracy and in terms of timing, how quickly you can get a test. And there's also different, specifically there's antibody tests, and there are tests that show an active infection. And don't quote me on this, but I believe the antibody test can detect the coronavirus for at least a month or 2 months after you were exposed and or contagious. So if someone comes in and they have an antibody test that shows that at some point they had coronavirus, but they can't tie it to the time in which they were allegedly exposed at the place of employment, that's a solid defense for these types of claims. So what type of documentation do we mean? We want to get the actual test results and not just a letter. So there are, the county health department will, a lot of times they'll issue a letter from a nurse saying, similar to Claim A originally, that the person was exposed to coronavirus and they've tested positive. Well, that's great, but we need to actually see those test results to be able to accurately defend the claim. Again, looking at the documentation of the employer's policy. Are there any witness statements? I mean, if for some reason the employee was removing their PPE against company policy, if the witness says, "Hey, I saw on Facebook that the employee was out at a had a huge party at their house with 300 people that none of them were wearing masks, and I saw all these pictures on Facebook." Well, that could show a potential basis for exposure as well. So I guess I jumped ahead a little too quickly there, but the conclusion to all of this, and I think if there is one thing that this whole presentation has stated so far, is keep paper documents of everything. So the testing or the training you provide to your employees, your policy, all of those are going to be critical down the line should you end up in a worst case scenario where someone actually contracts COVID-19. So the last portion of our presentation today is going to deal with some of the federal legislation that has been passed regarding coronavirus, and that the largest piece is the FFCRA, or the Families First Coronavirus Response Act. So before we jump into some of the changes that have occurred recently to this, Carl, could you give us just a brief synopsis of the FFCRA? What was it, and what was its purpose?
Sure. The the COVID-19 pandemic and then the resulting shutdown of our economy prompted Congress to create, in very quick order, a response package directed at economic stimulus, for lack of a better word. It's kind of a safety net. And the FFCRA applies to employers essentially that have employees, 50 employees up to 500 employees. So I don't know how Congress came up with that number, but that's the employers that are ordered to comply with the terms of this law. Now, the law, I don't know exactly when it became effective, but I do know that it is set to expire the end of December. Now, for our purposes today, even though we know honestly that Congress is going to extend this law, so it's going to expire technically December 31st, but it's going to continue on probably until June 1st of 2021. It has two main parts. First part is something called the Emergency Paid Sick Leave Act. And that's where when Rob was talking about the workers' comp claim and somebody being quarantined for 2 weeks, that's why I brought up the fact that maybe this person was double dipping. Maybe they applied, or maybe the employer went ahead and paid them 80 hours of leave under the Emergency Paid Sick Leave Act. What this is, it is designed to protect people who are sick with COVID-19. That's essentially what it is. There's another part of the law that helps people who have to stay home and take care of their kids. And that's something I'm going to talk about here in a second. But the emergency paid sick leave allows for 10 days of pay, up to 80 hours, if the employee qualifies, and there are 6 different reasons for that. The most common is if somebody is advised by a healthcare provider to self-quarantine due to COVID-19 concerns, or there's a quarantine ordered by some government agency, or experiencing COVID-19 symptoms and seeking a medical diagnosis. Those are the most common. And I don't want to go down the rabbit hole on this because pay is determined by which of the 6 reasons an individual is off for those 2 weeks. But that is one part of the Family First Coronavirus Act. The second part is something that's called expansion of the standard Family Medical Leave Act. It's called the Emergency Family and Medical Leave Expansion Act. So that's the second part of this big law called Families First Coronavirus Response Act. What the Emergency Family and Medical Leave Expansion Act, and boy, do you know how many times I've had to practice these words? FFCRA, Families First Coronavirus Response Act, Emergency Family and Medical Leave Expansion Act, Emergency Paid Sick Leave Act. I was in front of the mirror for a long time a couple of weeks ago because this is about the 3rd webinar I've done involving these to get through these words because they don't necessarily flow off the tongue. The expansion of the FMLA actually pays employees who are off of work because they need to care for a minor child. For example, you might remember daycares were closed for the longest time. And then when they reopened, they were on limited or restrictive basis. And then schools. So some schools are closed, some aren't. Some schools, their children go for 2 days and then they're off for 3 days. And then the next week they go for 3 days and they're off for 2 days. Well, for working parents, it creates a nightmare to try to deal with all of this. Well, the Expanded Family Medical Leave Act is designed to help employees go through this period of time. The employers are responsible for paying the employees, and then the employers get a tax credit at the end of the year. So that is the basic Families First Coronavirus Response Act. Now, one key provision, which is going to set the stage for the last part of the webinar that Rob's going to talk about this court case that came out. There was an exemption for healthcare employers. And these healthcare employers were excluded from this law if they were a healthcare provider or an emergency provider. The theory of Congress was that these are absolutely essential employees and they wanted to make sure that these employees were working. So they were excluded from coverage under the Act. And then all of a sudden, the court took a look at this and kind of made some changes to it. And Rob, are you going to cover that, or do you want me to cover
I can jump through it real quickly. So,
All right.
like all great pieces of federal legislation, the first thing that people do is file suit on it. And so, most recently, in August of this year, one of the federal courts out east declared several portions to be invalid and clarified a lot of language that was in the FFCRA. So we're going to go over just real briefly some of the changes that they made and what does that mean for you guys. And then we'll wrap it up here, and if you have any questions, we'll shoot for them. So first thing is it reaffirmed that employees who are not eligible for FFCRA leave if the employer doesn't have any work available. Now, it did clarify this by saying that the requirement applies to all for qualifying reasons to take paid sick leave and expanded medical leave, and that the reasons must be legitimate, non-discriminatory reasons for the unavailability of work. So the employer can't just say, oh, we don't really want you to work, so we're just not going to give you leave. If there's legitimate that there is no work, and obviously a lot of the industries that we had shut down and had a substantial decrease in work and ability to work, if there's a legitimate reason, they don't necessarily have to provide the leave. And kind of what Carl said, the definition of healthcare provider. So before, this was a very broad definition in the bill, and it now tracks along with the statutory federal definition. What does that mean, though? Well, that means that healthcare worker does not include someone such as a computer professional at a hospital, building maintenance at a hospital, HR professionals or personnel, records and billing employees that are in the healthcare industry that were originally covered under the FFCRA as excluded specifically. So it does say that a healthcare provider is defined as physicians or another who makes medical diagnosis and those that are capable of providing healthcare services. A healthcare provider must be employed to provide diagnostic services, preventative services, treatment services, or other services that are integrated with and necessary to the provision of patient care to qualify. So in a nutshell, doctors, nurses, yeah, those are still going to fall within the definition of a healthcare provider. The food service workers at a hospital are not. It clarified that when employers can require employees to provide notice of the need for FFCRA leave and with supporting documentation. The big takeaways from that is that the notice must be provided as soon as possible, which typically is before the leave is taken, and the documentation must be provided at the same time the employee gives notice. It reaffirmed that the intermittent leave under the FFCRA, so not a full block but intermittent, can only be taken with the employer's agreement. So based on that, what are the big takeaways from the changes that they've made to the law? First, obviously employers must follow the federal regulations. You're going to want to confirm that leave forms are consistent with the rules that are regarding notice of providing leave. You're going to want to update your policy. If you're in the industry, in the healthcare provider industry, you're going to want to make sure that the definitions are consistent with the language in the FFCRA. And lastly, it's very important that Carl really, I think, set the stage, or said it very eloquently earlier, that COVID-19 is a moving target. And every time we think we have something figured out, things change. So it's very important to monitor the Department of Labor website to see if there are these changes that go through, because they can have drastic impact. They can drastically impact your business.
Yeah. And feel free to send questions to us. And while you might be formulating a question, I'm going to ask you guys a question. Have any of you in attending today, have you had employees who have refused to work because they basically have a fear of COVID-19? And if so, how have you handled it? So we've run into this more often than you would imagine. And I will say this, that there is no federal law protecting individuals who purely are afraid of COVID-19. So they have no protection. If they don't show up for work, I hate to even say this because it's like saying, well, we're an at-will employment state in Ohio. And then you go through the exceptions, and the exceptions gobble up the rule. But what I'm saying is, just because somebody is afraid of coming back to work because of COVID-19 is not a justifiable legal reason to refuse to work, in which case employers can take appropriate action if they deem it necessary. Now, that said, you need to be concerned if somebody says they don't want to come back to work because of COVID-19. What if they have an underlying disability? I mean, what if they have a documented anxiety disorder, which we've run into before, or they have a chronic health condition like asthma or diabetes that places them at a high risk of contracting COVID-19 and having serious problems after that? So how do you handle that? I mean, it could be that serious health condition, underlying chronic health condition, might fall under the Americans with Disabilities Act, in which case you kind of have to engage in the interactive process. Could be that if they have a serious health condition, that FMLA would come into play. So you need to be careful that you don't just out and out terminate somebody, and the next thing you know, you get a lawsuit claiming that you interfered with their FMLA rights. So it is a sensitive, subtle area that HR people have to deal with while you're dealing with everything else. One thing I've learned over the years is HR people are very flexible, and they've just learned to deal with workers' comp, unemployment, government inquiries about, you name it, everything in the world, documentation, and on top of that, you have to take the time and go through an interactive process. Or even if somebody doesn't say they have a disability and they're requesting accommodation, you're supposed to be able to figure that out on your own. I only bring this up for just, I guess, food for thought for you guys to think about. It's some of the issues that we're running into in the COVID-19 world. And if you have any questions, Rob and I are more than glad to answer them. While we were talking about this Emergency Paid Sick Leave Act, and we had a client call us, today is Wednesday, called on Monday and said, hey, look, my first employee, they had self-quarantine, there's this emergency paid sick leave thing. I want them to take their 80 hours of vacation pay instead of that. And you're not able to do that. This law was specifically enacted to pay people due to COVID-19 reasons. So you can't require employees to exhaust their leave before they get that emergency paid sick leave money. It gets a little more dicey when you start talking about the Expanded Family Medical Leave Act. And actually, it's dawning on me while we're talking, we could probably do a 45-minute webinar just on FMLA and the emergency FMLA and how all of the application of leave benefits such as vacation pay, sick pay, and all that come into play, assuming that Congress is going to continue the law beyond December 31st, 2020. So I'm done talking. Thank you.
Working in a healthcare setting, if COVID enters the facility through an employee and residents and employees test positive within the next week of initial onset, would we need to add the employees to our OSHA log?
If they, the answer is yes, qualified, with the caveat that, you know, they're quarantined, that they're out of work, or that you require them to work remotely. So they you kind of enter into that flow chart analysis to determine whether something is recordable. And in that case, assuming they're quarantined, I think you're probably good to report it. OSHA has they've changed their stance 3 times on whether or not COVID-19 is recordable. I mean, forever, viruses like the flu virus, the cold, any sort of airborne virus was not a recordable incident. Now, all of a sudden, OSHA has taken the stance that COVID-19 cases are recordable. So you just do the best you can. Document your analysis and go with it. So my recommendation would be yes, that's recordable.
All right, it looks like that's it.
Great.
Well, thank you, everyone. Really appreciate it. And we'll see everyone at the next one.
All right. Thank you.